Hello everyone, good evening and welcome to this webinar organized by the Young Europeans Network. We get many questions about British citizenship after many people in the UK have settled status and are thinking about perhaps applying for citizenship. So it's a topic that we are campaigning on in the Young Europeans, in the 3 million Young Europeans Network, to have a more accessible pathway to citizenship. So we're really delighted to have our second Q&A British citizenship webinar with practical questions and answers this evening with Agnete Gribkowski, who is an OISC Level 3 immigration advisor, and she specializes in citizenship applications. So really glad to have another round of Q&A webinars. We'll wait for a minute or so for more people to join. I see people joining on Zoom and on Facebook as well, so that's great. If you're watching on Facebook, you can use the comment section to ask your questions throughout the webinar, and I will explain in a minute how the running order will look like. And again, on Zoom, we received a lot of pre-submitted questions from you through the Zoom form and through email, but if you have other questions, you can use the Q&A function here on Zoom, and with the chat on the right hand side of Zoom, some of our volunteers from the Young Europeans Network will post different resources and other materials. I'm one of the co-chairs of the Young Europeans Network. My name is Alexandra, so I'll be chairing the event tonight and asking some of your questions to Agnete. Also, hello to those following the live on TikTok. We opened a TikTok a few months ago, so really glad to be able to live stream those events to our new TikTok audience as well. So again, if you are on TikTok and you have questions, do ask them there in the comments, and my colleague, the other co-chair of the Young Europeans Network, Lara, will be on TikTok with you, commenting as well with you and taking your questions. So I see more people joining, so let's make a start. I will let Agnete introduce herself first, and then we can go through some of the pre-submitted questions. We received over 50 questions, so we try to group them into different themes. So we go over those main themes and main questions for about 40 minutes, then speak about our campaigning with Lara and hearing from some of the young Europeans who had experience of the citizenship process, and then we go back in the next and the last 30 minutes to some additional questions from all of those platforms. So Agnete, would you like to say a bit more about yourself first?
Hello, thanks for the introduction. My name is Agnete Gribkowski. I'm a level 3 advisor. That's OISC the highest level. Have been an advisor for 10 years. I run my own practice, Gribkowski Migration, and I also train and edit for HJT Training, who's in a training company for immigration lawyers, and I specialize in EU law and citizenship for Europeans mainly.
Thank you. So we received a lot of questions, first of all, about, just practical aspects of the application. So from, the transition between settled status to citizenship, to English tests, life in the UK tests, and the practicalities of the application. So Agnete, would you like to go through some of those practicalities, touching on some of those general questions that we received first?
Yes, so I think the first question is really good because it's very broad. So I would like to screen share something. The question was, what are the essential conditions to be met to be eligible for British citizenship? Now, there are there are different categories of citizenship that you can apply for depending on your circumstances. And we have created a document, a guidance document, which is currently published on the 3 Million website from the last Q&A in November. But I've updated this, and it will be posted again, the updated version, after this Q&A. So I'm going to try and screen share this here, because the question is a good prompt to look at the different categories that may be applicable. So it's straight right at the front, page 2. These are the categories. So probably most queries and most attendees today will be having inquiries or questions about naturalization, which is here at the bottom. So that's for adults 18 and over. So there are 2 different categories there, depending on whether someone is married or in a civil partnership with a British citizen. The main difference between the 2 is that for someone who is the qualifying period, the residence period is only 3 years, and it is not necessary to have held settled status for 1 year. They can apply straight away when they're granted this. Otherwise, the requirement is 5 years residence and one must held settled status for 1 year before applying. You can see that the absences allowable are proportionate to the number of years. So for the 3 years, it's 270 days, and for the 5 years, it's 450 days. So here we have at the bottom those requirements which are the same in between those two categories that I'm highlighting now. So we have no more than 90 days absence in the last year. The good character requirement that we're going to talk about a bit more later. The life in the UK test, English language, unless exempt, the main exemption as being 65 years or over. Probably not applicable to most people here. And the form guidance is at the bottom. The fee is the same for both, 1,330. And then we have the other categories, just in really brief outline, because the question asks what are the basic requirements. So we'll just really quickly go through these. For those born in the UK and still under 18, they can apply under Section 1(3) of the British Nationality Act. The requirements are very simple: to have been born in the UK and then one parent having become settled or British after birth. So there's no residence requirement there. It's relatively straightforward. The form is Form MN, so minor nationality or naturalization stands for, and the fee is here. Then next we have Section 3(1). So the section numbers sort of flipped around here. This is registration by discretion of children under 18 who were born outside the UK. The requirement is very vague because it's purely by discretion. So they essentially have to show a very strong connection with the UK. So family members who are British, having lived here for a very long time, all of that. So this is difficult. It's a difficult application. So it's always advisable to take legal advice for these to avoid a refusal. The good character requirement applies to everyone over the age of 10. Sorry. Then we have Section 1(4). This is another person who is born in the UK, but they can still apply when they're adults. So if you're born in the UK and you've spent the first 10 years of your life in the UK without any more absences than 90 days in any 1 year, you can apply. The fee is different according to whether you're a child or an adult when you apply. And then we have, this isn't really an application that you would make, but it's important to be aware of it. If you have children, for example, you need to be aware of the fact that your child, if born in the UK, and you may have already been a permanent resident, for example, at the time, may already be British, so they don't need to register. So I think I've gone through these categories, very basic. You can refer to this. The guide is available on the website. I'll go on to the next question. Applicants that are married with UK citizens, does the documentation required for the application need to go back 3 or 5 years? The simple answer is, as we've just seen, it's 3 years. It is, however, important to point out that this is the continuity of residence that we're looking at for the 3 or 5 years. The lawfulness of residence will be looked at for a time frame up to 10 years under the good character guidance. So if you've lived here for 6 years, they will look at 6 years. If you've lived here for 13 years, they will look at 10 years, because 10 years is the maximum. And we will look at lawfulness in more detail. The next question. This is someone who will have had settled status on 10th of November this year. They're asking, can they apply on the 10th of November this year? Then the answer is, obviously there's not a lot of information. I don't really know where they fit in. Are they married to a British citizen or not? So we've seen what the difference is. If only looking at the requirement to have no immigration restrictions, then yes, they can apply on the 10th of November. If they're married to a British citizen or in a civil partnership with a British citizen, then they can apply now. But what's really important, and I would point out here, is as to timing of applications, it's very important to be aware of whether the 5 years or the 3 years apply to you, and then to look back at your travel history to make sure that at the beginning of that period you were in the UK, because if you weren't, that can be a ground for refusal. The next question is very simple. Are over 65s exempt from the English test? The answer is yes. That's a blanket exemption. They're exempt from the Life in UK test as well as the English test. Question after that, procedural. The referee forms, do they need to be printed? Is there an online form to submit? Unfortunately not. The whole application process is online except for this element. So they haven't, UKVI haven't quite caught up. You have to print them off. You have to get a passport photo, old-fashioned, write on the back your name, date of birth, and then glue that to the form and give it to your referees to sign and date. All the rest of the information you will already have entered into the online application form. So, next question. When do I have to do the biometrics is the next question. Before submitting the form and before paying, or do I make the payment and then find somewhere to do the biometrics? And then the question is, where can I find a place for this? So the procedure is, or the order of things is this. First you gather your information and then you start your online form. Once you've completed that, you submit. It will then take you to the payment page. You make the payment, which by the way includes £19.20 for the biometrics. So you will actually be paying £1,349.20 instead of £1,330 in case that surprises you. So this is what happens. Once you've paid, you will then see a page that has downloadable your checklist and your referee forms, and it also has a link to where you can book your biometrics appointment. You then just follow that and you sign up with Sopra Steria, which is the privatized partner of the Home Office that deals with the in-country biometrics appointment. And then in between your booking of the biometrics appointment and attending your biometrics appointment, you can then upload your evidence. And I think that covers the order of things. Next question, who can I use for a reference to apply? Now this, let me see, there is guidance. One moment. There's guidance and I will try to share that. Nope. Sorry, I'm not sure where this guidance has gone. So essentially the guidance, sorry about that. The guidance states that one moment, I'll just bring that in. So the referees must be British citizens, and one of them must be a professional. They must not be related to you. They must not have criminal offences. And then on page 25 of the guidance, which is linked to from my guidance document, so the 3 million guidance document, you can see a very long list of professionals who are acceptable for referee purposes. I'm sorry about that. The links are in the guidance document, which I will share again. I think that would be a good idea to keep referring to it. Here we go. Okay, so next question. I already have settled status. When can I apply for the passport, and which exactly is the whole procedure? I think we have just covered that. What the procedure is and who can apply and what are the categories and so on. So we'll actually leave that one out. Next question. I have recently acquired the EU settled status. However, I now see that I have to wait one more full year to apply for citizenship. So that is correct, unless you're married to or in a civil partnership with a British citizen, as we covered before. So in that case, you can apply on the next day or the day that you get your settled status. There's no need to wait. This is the second to last question in the general section. When I applied for the EU settlement, I submitted the last 5 years evidence starting from the application date backwards. However, I also had additional years before those. Can I request for the settled date to be backdated so I don't have to wait 1 year for the citizenship application, or is it too late for this now? Obviously, the evidence can be provided. So that's the question. Now, different from permanent residence, this cannot be backdated. So the date of the date when you are considered free of immigration restrictions is the date that you're granted settled status, and not the end of the 5-year period on which you rely. So this person could have relied, for example, on 7 years ago to 2 years ago, that 5-year period, but nevertheless, their grant of settled status will be now. So there's no way of backdating that. Permanent residence was capable of being backdated, but those applications are closed now. Then the last question in the general section is, where can I find all the resources I need to practice for the test, the books and the mock tests, etc. So the questions and answers will be published with all of the links that I've put into the relevant Gov.uk pages and Home Office pages. So there is essentially, you can easily find this. So if you Google Live in the UK test, you get to a Gov.uk page, which will link to the resources. So there's a link in there, which I've also provided in the Q&A, which you can refer to later. So that was that for general questions.
Thank you very much, Agnete, for that. So now we're moving on to a lot of questions about evidence. People asking what kind of evidence they need to submit, especially many questions from people who are self-sufficient, stay-at-home parents, people who are students, and a sort of confusion around what types of evidence as well. Questions around, are bank statements enough, and general. Could you give a more general picture about the type of evidence that is required for citizenship applications, and we can cover some of the pre-submitted questions on this topic. And I'm aware there are a lot of questions coming in, so thank you for your questions on TikTok, Facebook, and Zoom. We're compiling all those questions, and we'll address more specific questions in the second part of the webinar. But first of all, those more general questions about the types of evidence from the pre-submitted questions.
Yeah. So I think the first thing I would point out is that something strange has happened to the form. When you submit the form, you get an outline of the evidence to be provided. And sometimes this does state, and a client brought this to my attention, that bank statements are not admissible. Now, this doesn't feature anywhere in the law or the guidance. The guidance gives examples of types of evidence that can be used, and evidence from government departments or sources are preferable. That's always been the case, but I don't see any legal basis on the Home Office ignoring or disregarding bank statements. Of course, with the proviso that if you have bank statements and they show no transactions whatsoever within the UK, only maybe online bill payments coming out, then that isn't very solid proof of your actual presence in the UK, because you could have been outside the UK. But if the bank statement shows regular transactions on the UK high street in UK shops that are clearly UK, so Boots, Sainsbury's, or so on, then I don't see how UKVI can disregard that. So do use them if you don't have anything else to hand, but sort of have in mind that hierarchy. If you have documents from government sources, HMRC, anything from HMRC is good, the NHS is good, anything else, DWP, anything in relation to benefits, then prioritize that. And then draw yourself up a table of years and months, and then sort of add what evidence you have for which month, and then it will be very easy to see where the gaps are. And if you really have nothing else to provide in terms of your proof of residence, then you can definitely put in a bank statement here or there, but maybe, prioritize other things first. So the first question is an interesting one. Which are the best documents to submit in order to prove residence if you are a stay-at-home parent? So I said the guidance currently prioritizes especially work evidence, so that's their starting point. But it doesn't exclude other types of evidence. So for stay-at-home parent, I would suggest child benefits, any other benefits. You can use GP and or dentist appointments. For example, you can just request a list of appointments. You can use school records as well, or school records or letters addressed to you as the parent. What else? Yes, I think that's it. So that would be a good range of evidence to resort to. Let me see. Let me just make sure that we don't cover anything that is sort of repetitive. Yes, the next question was, can I submit utility bills, council tax bills, tax credit award letters? Yes. So I've gone through that already. The next question is, can I submit my BRP, the biometric residence permit, as proof of immigration restrictions? So what they mean is being free from immigration restrictions, or would you recommend other proof? So you don't really have to, because all you have to prove in relation to that is that you haven't lost your indefinite leave to remain or your settled status, which will be proven already by the fact that you're putting in all the residence evidence. So the way to lose other types of ILR is by an absence, or a whole absence of 2 years, or settled status a whole absence of 5 years, which isn't even possible because settled status hasn't been around that long. Plus, you're providing all that residence proof, so thereby you're already proving you still have your freedom from immigration restrictions. So no, you just need your BRP or your proof of settled status. The next question is interesting. I am self-employed. As proof of self-employment, is it enough to submit my latest tax return, or do you recommend any other documents? So it depends. If you're relying on that as residence proof, then your annual tax return plus any other proof of your self-employment will be good, but not essential. But if you're relying on these documents as your residence proof, then, for example, this person is self-employed, but they have wage slips as well. So I would recommend putting those in as well to have more of an even spread of evidence. Should I submit my bank statement is the next question. We've covered that already. So deprioritize them, but they're not excluded by law. I think someone got a little overzealous in drafting that post online form submission text. It's just not in accordance with the guidance, so you can still use them, yes. As a software developer, I had a limited company for 1.5 years. Are the certificate of incorporation and the P60 sufficient? So I've sort of answered that already, where this is self-employment. So the P60s per year would be sufficient proof of that ongoing self-employment. But as I said, if that is then also used as the residence proof, then there should be more in between. Roughly every 2 or 3 months, I would aim for proofs of residence. 2 more questions. Okay, so this is just a quick outline. What documents do you need to apply for citizenship if you already have settled status? So really briefly, you need proof of continuity of residence. You need proof of holding settled status. If you're married or in a civil partnership with a British citizen, then you need to submit that passport as well, plus the marriage certificate for the civil partnership. Then you need proof of English language and right of UK test, and proof of lawfulness of residence for up to 10 years, as mentioned before, plus obviously your passport. Last question. This is also interesting. Can I provide tax screenshots from HMRC in conjunction with letters from employers to prove I worked for 5 years? So I would say yes, you can, as long as it shows your UTR, unique tax reference, for example, or your national insurance number. Yes, but it would be preferable to make a subject access request to HMRC for your employment records. It's also easier for you to refer to. It takes about a month for them to be issued, and the link is in the Q&A document that we'll post. So it's a straightforward application. It's a 1-page form. So I would always recommend making that request if you have time.
Thank you, Agnete. We have a few more questions coming in about specific types of evidence and more details as well. So again, we'll return to those in the second part of the webinar. But first of all, let's approach another topic where we got a lot of questions, especially now in the times of COVID, many questions about absences, going into more detail in the absence requirement, what exemptions are there for absences, how precise people have to be with their travel history, and how can absences, longer absences affect the application. So I think there are quite a few questions there. Now again, let Agnete respond to some of the questions we heard in advance before approaching in more detail later on.
Yeah, so the first question was, I read that I can spend up to 6 months outside the UK. How can I prove how long I've spent outside the UK? So how to prove your absences? I've gone through the number of absences and the number of years, but that again depends on whether you're married or in a partnership with a British citizen or not. I don't know that, but let's concentrate on the absences. So you can prove your presence in the UK with the proofs of residence that we've just talked about. And the naturalization guidance, which is linked to in the Q&A on page 15, gives examples as well. For your travel history, you can use boarding passes, and you can go through emails, for example, for proof of travel bookings and things like that. It's not always possible, so you may also not have anything in your emails. You may not have any record at all. In that case, the application form is going to ask you, well, in all cases, the application form asks for dates of absences, so date you left the UK and date you came back. Some people have to estimate that because they simply can't find any proof. If you do that, the main thing is to then also write in your covering letter or in the box for extra information that you have estimated those dates, but that you know that any additional absences will not bring you over the maximum allowable absences, so that you have a vague idea that you may have been absent for 2 days in this year or something like that. You simply don't know the dates. As long as you state what your estimate is and what you've had to guess, then you're fine. As long as you don't simply state any dates and then later on it comes out that the dates are different because you wouldn't want to misrepresent things. As long as you stated you're guessing, then you'll be fine. The next question is, how precise do I need to be with my travel history? Same thing again. If you need to make your best estimate, just state that that's what you've done. There won't be generally entry and exit records kept by UKVI, especially for Europeans. You will not have been stamped in, and unless when leaving, you don't use the e-gate, so there won't be any record of you leaving. And coming back, there might be a record if you're coming back through the e-gate, but it will simply be too inconsistent, so you just have to give it your best shot. Applications used to ask for the number of trips abroad. So this is a question about how can I find out about my 30 years of travel. So you only need to put in the absences for whatever your qualifying period is. So you only need to put in your absences for the last 5 years, or if you're married or in a partnership with a British citizen for the last 3 years, because it's irrelevant for the rest of the time. This is the time period for which you need to prove continuity of residence. I also need to warn, I had a case where someone was a business traveler, constantly traveling, and they had more than 30 absences, and actually the online form doesn't allow for that. So then just add with your other supporting documents the spreadsheet where your client, or where you will have set out your absences. If you have that many absences, it's best to do a spreadsheet and then just add that into your supporting documents and cross-refer to that. As I said, there is a box in the online form allowing you to state anything that wasn't asked for in the rest of the form. So you should mention there that the absences exceed the number of absences which the online form can take, and please refer to the spreadsheet, or you can do a list on a table or whatever, it doesn't matter. How long can I be outside the country in a year? I believe I once passed the limit of 90 days in a year, but would it affect me as a whole for the 5-year period the government is asking? So it's important to remember that the total absences over your qualifying residence period is calculated across the whole period. So as long as there wasn't an absence right at the beginning, so 5 years before you apply, you can't have been absent then, but they can have been spread out in any which way, as long as in the last year, they are no more than 90 days. So it doesn't matter, you could have taken the entire absence in 1 or 2 years. So you could have had a very long absence, it doesn't matter. So someone is asking here, can you explain the absence rules? If I've been absent for more than 3 months in the last 12 months, medical reasons, okay. So 3 months could be a bit more than 90 days. I don't know which month. But if it's under 90 days, you don't have to give a reason at all. Medical reasons, Yes, there are exemptions. So in the naturalization guidance, which is linked to in the document and will be in the Q&A as well in this answer to this question, there are exemptions. So I'll just quickly go through these because I think this is important and people have this question at the moment, particularly because of COVID and longer absences. So that states that looking at an excessive absence over the last year before the application, if your absences are between 90 and 100 days, then discretion should generally be exercised. That means that the Home Office will make an exception. Only where your future intention to make the UK your main home is given, so you must answer that in, correctly, and it must say yes. There's a written form to ask you your intention. And if it isn't contradicted by the evidence. So if it looks like you're just about to move abroad, then that won't work. For absences between 100 and 180 days in the last year, discretion should only be exercised. So the Home Office will only make an exemption where you can demonstrate strong links to the UK by proving that you have family here, employment, and your home. Home is not defined. You don't need to own your home, but you need to be renting, obviously. And then, let me see. There need to also then be exceptional circumstances. So these are then stated on page 16 of the guidance. So the requirements are that it should meet one of these requirements, that your qualifying period is preceded by a 2-year period with no significant absences, and that isn't defined. So if you're looking at someone who needs 5 years, if they can prove that in the 2 years before the 5 years, they never had long absences. So let's say, something less than 90 days per year, then that will be an exemption or an exceptional circumstance. Or where the absence was due to or because of a posting abroad in Crown service or accompanying a British spouse on an appointment overseas, or where the absence was an unavoidable consequence of the nature of a career. So it's someone who was posted abroad on work, or where there are exceptionally compelling reasons naturalization should be granted. So someone needs their British citizenship for a firm job offer. And lastly, where the excess absences, so that where the longer absences were because you were unable to return due to global pandemic. So that has now been added to the guidance. The next question is very similar, but it refers not to the last year, but for the whole 5-year period. So someone who exceeds the 450 days over 5 years. It says that if your absences are no more than 480 days, discretion should be exercised unless there are other grounds why your application would be refused. And if your absences are between 480 and 900 days, one of the reasons, again, that are included in the guidance now is where you were unable to return to the UK because of global pandemic. So it doesn't state, it's not very strict, so it could have been anything. It could have been family reasons. It could have been anything to do with the pandemic. It's quite liberal. The last question on absences is, I studied in the UK from 2017 to 2021 and went home for 6 months because of Corona. Am I eligible for citizenship? So we've gone through this. Unless this person is married or in a civil partnership with a British citizen, and even then, depending on their date of leaving, this would probably not work. If they're not, then they would need to complete 5 years plus have been granted settled status, so that also wouldn't work with the date. Lastly, depending on whether the 6 months was actually 6 months or just over, in terms of actually achieving settled status, if it hasn't been achieved yet, then there is specific guidance for EUSS that is, when you Google EUSS COVID guidance, it brings up the new UKVI guidance on how they treat absences of more than 6 months. So you may still be able to progress to settled status despite a longer absence. So that will be linked in the answer to this question in the document that will be posted later.
Okay, thank you for. I mean, there's a lot more questions on different absences, and obviously each person's situation is different. So it's important to obviously keep track as much as possible and keep the evidence of this. But moving on to the next topic, we have a lot of questions. Probably the most questions we received were about comprehensive sickness insurance, including some questions live now on the Q&A chat on Facebook as well as on other platforms. About there's quite a lot of confusion around this 10 years versus 5 years of lawful residence, as well as how CSI affects, for example, a question here, how it affects full-time students working part-time, if it affects this category of people. So I'll again let Agnete go through some of the questions regarding comprehensive sickness insurance that you asked in advance, and also in the break in between this set of questions and the next set of questions, we'll also hear from someone who has this CSI issue as well, from Lara to speak about her experience as well. But first of all, let's go through some of the questions about the CSI issue.
Yeah. So just really quickly, I've scrolled down in the guidance document to the section on CSI, which is quite extensive. So it just goes through, just to go through really quickly where this comes from and why is it important and why are we looking at 10 years. It comes down to the requirement to be of good character. Then there is guidance about good character. And this says that one of the elements that will be looked at is your lawfulness of residence over the last 10 years. And it is this bit here, compliance with immigration requirements. For Europeans, this means that they must have resided in the UK in accordance with the free movement regulations. So I'm just going to refer to them as that. Now I've just set out really briefly what that is and what boxes you need to tick, just so that you understand what fits where. So as a European who hasn't yet been granted permanent residence, back then most people didn't apply for any documentation. Their lawfulness will have depended on exercising treaty rights. So there are different ways of doing that. That was not necessary within the first 3 months after arrival, because you had an initial right of residence here under that regulation there. After the 3 months, to be lawful, you need to have exercised treaty rights and become a qualified person. So someone who exercises treaty rights is a qualified person. That's terminology. I've set out here what that is just very briefly. To exercise treaty rights and be a qualified person, you need to have been either an employed worker, self-employed, a student, or a self-sufficient person. Okay, but it is only students and self-sufficient persons who also needed to prove that they have comprehensive sickness insurance. So anyone who was a worker or self-employed doesn't need to worry about that for the time that they work. Obviously, someone can be a student and also at the same time be working. So where's the cutoff point? The rules are not very defined in terms of what is genuine and effective work. So there is sort of a rule of thumb. There are 2 rules of thumb. UKVI has introduced this sort of easy rule where someone reaches the primary earnings threshold from which they need to then pay national insurance contributions. If that can be shown, then they will not ask any further questions. So you simply show your earnings per week, which is set out on the HMRC website. So if you Google primary earnings threshold HMRC, it will bring up the current rates and the rates in the past, which will have applied at the time for you. So if you have that, then that's enough to prove that you were a worker. Even if you were a student, if you reach that income amount, then that's enough. But even if it's less than that, you can still be classed as a worker. It needs to have been sort of it needs to be not marginal and ancillary work. So if it's 2 hours per week, then probably this won't be enough because it won't make a big difference to your income. You know, you can't be said to be living on it. The rule of thumb here is roughly 10 hours per week. So if you are working more than on average 10 hours per week, then that should generally be acceptable, but it's really a sliding scale. You should probably, if you're near that or below that, you should seek legal advice. So then this is also important to understand because it feeds into all of this. Once you've done this, all of this, once you've exercised treaty rights for 5 years in the past, it doesn't matter when, you will have become a permanent resident automatically. So you may not even know it. You needn't have applied for permanent residence. You will be a permanent resident automatically by operation of law. So you can still bring proof of that, proof of your 5 years exercise of treaty rights and continuous residence to prove that you were a permanent resident. From that point onward, all you have to prove to evidence that you were lawful, in that your status was lawful in the UK from that point onwards, is to prove that you haven't lost permanent residence. And to prove that, all you need to bring is proof of no absences of 2 years or more. So this is where it gets really confusing because you're talking about different time frames. For example, someone who exercised treaty rights from 2005 to 2010 continuously, or their family member. Just to complicate things, I'll go back to here. A family member of someone who does this, so a spouse or a civil partner or a child who has exercised treaty rights will also have the same rights and they will also have become a permanent resident. So that could apply to you. So if to go back to the person who was exercising treaty rights for 5 years from 2005 to 2010 and their family members, in 2010 they will have become permanent residents. So to prove that would be continuous work and continuous residence. Thereafter, all they have to prove is points of contact where they were in the UK within 2 years of each other to prove that they weren't absent. Then we're getting up to the point in time 5 years ago, from which time onward you do then need to prove your continuous residence, because we're then talking about the residence period for naturalization. So this is quite complicated, but it's sort of going back in time to see whether something happened by law that made you a permanent resident, which then proves your lawfulness from that point onwards. Alternatively, let's say someone arrived 9 years ago, they were exercising treaty rights from 9 years ago, and they never applied for permanent residence, they got their settled status a year ago. So what you could do there is you could still point at the permanent residence having been accrued after 5 years of working. Quite complicated, but there's no need really, because what you could do is simply prove that they have always exercised treaty rights throughout that time. So there's different ways of doing it and different ways of fitting the time periods together, obviously not forgetting that family members are also included. So if you have a family, or if you are a family of Europeans where, for example, you could have a family with young children, sometimes, maybe, one of the partners took a year or two out of work, but the other one was still working, and then they may be changed. You can take turns in exercising treaty rights, and your partner will then, or your spouse rather, will then be able to rely on that for their own lawful residence. So this is why we've created this guidance document, because it's a little bit too much probably to take in, but hopefully this will be helpful in terms of improving. I think, should I go through the questions here to see? Yes, I think we can go back to the questions. The first question under CSI is, how shall we explain the lack of CSI in our application for citizenship? So this is someone who hasn't got the permanent residence and hasn't got the exercise of treaty rights in other ways. So they needed CSI, but they didn't have it. So the naturalization guidance, as well as the good character guidance that the Home Office looks at to decide these applications, recognizes that many Europeans were not aware of this. Well, not in those terms, but they have introduced a discretion that allows naturalization still to be granted despite the absence of CSI. So I've set this out here. These are the bits from the guidance that you can refer to in your covering letter. It would be a good idea to explain, this is what the question was, to explain the lack of CSI, comprehensive sickness insurance. You simply write a statement, just means you write a letter setting out, what your thoughts were, why you didn't think you needed private medical insurance and that no one ever told you. Which is, quite likely because neither universities nor GP practices informed anyone at the time. And then, the guidance though does state that where someone in the past applied for permanent residence and was refused due to the lack of CSI and then didn't obtain CSI, there would be in more trouble because they cannot then feign ignorance. So it would be more problematic, but that doesn't apply in most cases. The next question is requirement to have, so this is what the question says, requirement to have CSI when not being employed. Does it apply to the period after I got settled status or before that? So the simple answer to that is only before that. Once you have settled status or even pre-settled status, your residence is lawful because you have been granted that, even pre-settled status. There's no requirement of CSI anymore. And next question, as a self-employed person, do I need CSI? No. So we talked about employment and self-employment. They're both categories where CSI doesn't apply. So there is a question here by someone who has been granted indefinite leave to remain under the Windrush scheme, and they ask, is there an exemption for people who have been in the UK for a very long time? There isn't any such exemption, but my answer to that would be someone who was granted indefinite leave to remain under the Windrush scheme, there would have been a recognition by the Home Office that they got their indefinite leave to remain on some other basis, probably some time ago. So for them, the answer would be to go through their paperwork, go through the application and the grant letter to see when that point in time was. And then if it was more than 10 years ago, they will have been covered by that grant of ILR on the basis of having obtained indefinite leave to remain at that point in time in the past. I'll just be conscious of time. How many questions should we go through, do you think?
I would say maybe a couple of more on the CSI, and then we can move on to child applications, and then we can have a break. And after we can speak about our campaign a bit, and then in the last half an hour or so, we can actually go through some of the more specific questions because I see there's so many questions. So we're collecting those meanwhile. So keep on sending them, and we'll address some of the questions as well in the second part. So maybe a couple more on CSI, and then moving to the children questions.
Yeah. So someone asked, and this is probably good to disperse misconception. Someone was told that they need comprehensive sickness insurance through their employer. That's not true. So if you're employed, you're a worker, CSI does not apply to you. So that's that. Someone here has worked and studied and then started working full time. I think I've already addressed that. So if you're a student and also working, you could be classed as a worker, depending on everything I went through earlier as to what level of working do you need to be classed as a worker. So that's not directly, it's sort of related to CSI. The family question here. Do I need private health insurance to apply for citizenship? My family and I have been in the UK for 10 years working and studying, and we had never had the need for private healthcare. So it's not about the need for private healthcare because we all have access to the NHS. So it doesn't really arise, which is why people aren't aware of it. But as I said, so look at, who in the family was doing what, and then whether the other family members could rely on that exercise of treaty rights, even if they themselves weren't. Let's see which one is the best question to bring in here. I think, yes, so an EHIC card from another country, and that be used as proof of CSI. So that's a strange one. You can use it as long as you can prove that your intention at the time was only to remain temporarily in the UK. As to what else can be considered to prove that you met that requirement, that you had comprehensive sickness insurance, there is a list of documents in the qualified persons guidance, which is linked again in this document here. I think I have a list here. Okay, here we go. So these are the other documents that can be used. These are different certificates, which basically all mean that if you had needed NHS care and the UK government had wanted to claim those costs back from your own country, that they could have done. So these are the types of certificates. There is also an exemption, though, of what kinds of insurance don't count, definitely do not count as CSI. So here we have cashback health schemes for dental, optical, or prescription charges, or travel insurance. That doesn't work. However, even if you don't hold any of these certificates or their old names, so these are the new names and these are the old names, right? And the guidance says what they are, so you can have a look at the guidance. This guidance up here, when you go to the document, you can go to that link. Even if you don't have that, it will be worth having a look at this research here by an EU rights clinic. And they've gone into what other types of health insurance there are in other European countries. It can differ from state to state. You may be covered under a different scheme that UKVI aren't aware of. If it does the same thing, where the UK government could have claimed back health costs, then you could still make representations that this should count as the equivalent of comprehensive sickness insurance. So definitely have a look at our guidance document at page 6, which goes into all of that and takes you to all the relevant guidance.
Okay, thank you. Thank you for that. I think we have, quite a few questions around children and what types of applications are appropriate for children in different situations. And I see like one in the chat as well about how to prove the first 10 years of someone's life if going for that type of citizenship. So yeah, if you can go through some of those questions, a few of those questions around child applications, and then we can move on speaking about a bit about the Young Europeans campaign. In the last 20 minutes, we'll go back to some of the many questions that you asked here on the chat. I tried to also answer some of them in writing to let you know if the question will be, considered. We collate everything at the moment. So let's move on to the child citizenship first and the registration as well, the questions around registration.
Yeah, okay, no problem. So just to go back to this guidance document, which packs in everything really. I addressed that earlier. So these are the categories for children under 18. Here you can see section 4.1, section 1.4 also applies to children. So this is the one with the early years, having spent the first 10 years of your life in the UK. How do you prove that? I'm not sure if this is one of my pre-submitted questions, but essentially, just really quickly, if you were born in the UK, your parents will have a red book. So the first few years of your life, you need to get lots of immunizations and checks by the GP. So that will be there somewhere. It will also be in your medical records. Then medical records, again, go to your GP, get all appointments printed off for you, or your full medical records if you don't have anything else, but most likely you will then have, from the end of the red book, you may have nursery records, and then also school records will start from then on. So the easiest way to prove is simply by contacting the schools, asking for enrollment and attendance records if possible. So if you had 97% attendance, then obviously you weren't absent for that amount of time. So this is an outline. These are the standard documents plus anything else that is added to it. Children. Now, the first question is this. I have one child born in the UK and one who came to this country at 6 months old. What would be the different forms I need to use? So for the child born in the UK, I don't know whether this person was maybe a permanent resident by the time that child was born. So there wouldn't be any form that is needed, because if that was the case, the child is already British and they would simply apply for a British passport. If that isn't the case, child born in the UK can apply either under this. So once you as a parent get your settled status, they will qualify for registration as a British citizen here under section 1.3. And the form is then MN1. There's form MN1 guidance here for how to fill everything in and what evidence you need. If the child has lived in the UK for 10 years, so for example, you're having problems with your settled status for whatever reason and section 1.3 doesn't work, then they can rely on their own residence for 10 years. And I've just gone into a little bit of the evidence that can be used for that. The child who wasn't born in the UK would have to apply under this section here. As pointed out before, this is a more difficult registration application, which is completely by discretion. So it's difficult to know exactly how to build a case. So always seek legal advice, even if it's just a one-off consultation with a really good lawyer. They will be able to set you on the right path at least. So probably not attempt this without legal input. The next question: child 11 years old, born too early for naturalization. What document do I need to prepare? MN1 is quite vague. So I think here I would point to the guidance registration as British citizen : children, which will be linked in the answer to this question in the Q&A. So you can go to that and it sets out exactly for each of these categories what evidence they will expect to see. So it's quite a helpful guidance to refer to. It's just not linked to from the gov.uk pages, which is quite annoying, but you will have the link. So next year, the next question says, I could apply for British citizenship. I have a 7-year-old kid. How could we manage this process for my kid? So again, the process will depend on which legal basis your child applies under. So again, refer to this table here to identify which category they fit into, and then go to the form and the form guidance, or also the guidance document which I've just mentioned about registration as British citizens for children, which is quite helpful. The last question, no, 2 questions, but they're really quick. Can I use the same referee for both my children when applying for their British citizenship? That's yes. But for children, referees also need to have, so the professional needs to have known the child in a professional capacity. It's a bit different to adults applying for naturalization. They can just have a friend who's an engineer or some other professional. But for children, it needs to be a professional that has engaged with the child in that capacity. But if you have 2 children and use the same referees, that's absolutely fine. Last question: if I get British citizenship, are my children getting it automatically as well? No, but they will then be eligible to apply under this section, which is quite an easy application. Unfortunately, it's not cheap. This is the fee currently. So these are the questions on children.
Thank you very much, and thanks everyone who keeps on submitting the questions. I'm trying to work through some of those questions on Zoom, and like some of our volunteers are adding them. So I think now, because we collected quite a lot of questions for the second part, and we have about half an hour left, what we'll do is we'll have like a 10-minute break for Agnete to actually be able to look at some of those questions, and then we'll speak a bit about 10 minutes or so on our Young Europeans campaign whilst Agnete is looking at the questions that you submitted live now. And then at the very end of the webinar before 7:30, we'll also give some pointers as to what to do next in terms of legal advice, or if you have any further questions as well, and how to find support for your application. So whilst Agnete is looking at the questions, I would invite Lara, if Lara is here, to introduce our Young Europeans Network citizenship, access to citizenship campaign, which started a few months ago in the autumn of 2020, when we actually had, shortly after, we had the first Q&A webinar with Agnete actually. So Lara, over to you. And Lara will also speak about her personal experience of the barriers she encounters in citizenship process, and I will add a more positive story of someone who actually got citizenship after a long journey. So Lara, over to you.
Yeah, thank you. I am both here and on TikTok, so I'm like looking at two cameras at the same time. So yeah, I'm the other co-chair of the Young Europeans Network, and amongst our group, we've got a lot of young people that want to become British citizens. We're talking about people that maybe like me have lived in the UK for a few years, have studied in the UK, have made like friends, got family in the UK, and don't plan to return to the country where they were born and really want to become citizens. Others have lived here their entire lives and don't know anything else, and are British in everything but their documents. So this campaign is really important to us, and we try to make sure that everyone's stories is included in our work, in our campaign, because I think there was a question in the chat as well, like what are the benefits of citizenship over settled status? There are a few, although it's not like settled status does cover a lot, it does offer you a lot of security. But in my personal opinion, the reasons why I want citizenship is one, a key one, so that I am able to vote in general elections, which I am not able to do with settled status. But also, as I said, I've lived in the UK for 7 years and more, and don't think I'm going to go back to the country where I was born. So having British citizenship is now something that I would like to have to match the identity that I have. So it's really important that we do have that in our conversation about becoming British. And then there are other reasons as well why some people may want to become British. Some people don't feel that settled status is secure enough. We're not here necessarily to have that debate on whether it is secure enough or not, but we need to make sure that like recognize that some people don't feel secure enough with settled status only and want citizenship for that reason as well. And others, as I said, like just feel British. They were probably came here at a very young age. But then we also have even though we want to become citizens, there are lots of barriers to it. And the fact that Agnete has received 50 plus questions and questions are still coming show the level of complexity towards the path of becoming a British citizen. It is complex. There are lots of traps that people can easily fall into if we're not careful. For me specifically, the main barrier that I face to becoming a citizen is the comprehensive sickness insurance, which was this last theme that Agnete just covered, the one before children. I did my A-levels in the UK, and when I was doing my A-levels, I was studying full-time and working part-time. But when I started university, I stopped working part-time, and for those 3 years, I only did like holiday work, but it wasn't considered as substantive. It didn't meet that like minimum 10 weeks general requirement to make sure that my work could really be considered as substantive. So then when I applied for settled status, I now have had settled status for over a year, and thought that like, okay, time for me to become a British citizen. I bought the life in the UK, test book to start studying for the Life in the UK test. And then through involvement with the 3 Million and the Young Europeans Network, I was like, oh, actually, I still can't because I didn't have this comprehensive sickness insurance thing when I was at university. So I fall into that category of someone who didn't know that I had to have comprehensive sickness insurance to one day be able to apply for citizenship. And to be honest, when I first arrived in the UK, I didn't know that I wanted to become a citizen. I didn't know how long I was going to stay in the UK for. But now that I do want that and realize that I can't have it, it is quite disappointing. And that's why we are so keen to be able to inform people so that they are able to decide what step next to take based on actual real information, so that they don't fall into any traps, so that they don't make an application that is likely to be rejected. But also, like with CSI, as Agnete said, there is a possibility that you can try to ask for discretion and say why you didn't have it. So those are all things that are worth exploring, but generally we can all see how complex it is to become a citizen. I just covered my specific reason of CSI, but besides that, there is the cost. Even if I was able to pass the CSI test, I don't even know if I would be able to have that much money saved right now to apply for citizenship. And just generally, some of the other members in our network have talked about the complexity of it as well. Like the many forms, the many paths to citizenship, registration, entitlement, naturalization, that there's quite a lot. So it can be difficult for a young person or just anyone to be able to understand without the level of expertise that Agnete is bringing today. But I'm gonna, this is my story of why I haven't yet been able to apply. But you can hear from Alexandra a more positive story as well.
Okay, I'll speak about my story for a bit, and I think at 7:10 we'll return for the last. Can you hear me now? No? I'm not sure what's happening. Is it better now?
I can hear you.
Okay, I think Lara cannot hear me for some reason. Well, if everyone can hear me, that's fine. If you let me know in the chat. Okay, Shukri says so maybe Lara has an issue with her connection. So yes, Lara explained about some of the barriers of citizenship. I'm one of the people who as well thought I can't apply due to CSI, but I found that, and I see a lot of questions about this as well, about working during your studies. So like many other people in the comments, in the chat as well, I assume just because I was a student, I couldn't apply because I didn't have CSI, until I actually discovered that, hey, if you actually worked part-time like I did, you can actually qualify as a worker. So it took me some time to put all the evidence together, and I did have some advice as well in my application, and that's why it's really, really important to actually get appropriate advice, either by coming to one of those sessions or following up with some questions, speaking to an advisor about your case, because this could actually really help put things into perspective and have a successful application in the end. People ask always, like, why, what's the advantage, why apply for citizenship? I would like to stress this because, so not to get people like panicked about things. Settled status is indefinite leave to remain in the UK. People ask about, if this can be lost. If you are abroad for more than 5 years in a row, yes, this can be lost. But settled status covers most of the rights we already had. So the rights to work, the rights to access welfare, the right to study, and so on. The only thing, one of the few things that's still under negotiation is actually the continuation of voting rights in England and Northern Ireland in terms of the local election voting rights that are not linked to settled status. But other than that, things are pretty much the same with settled status from that perspective of being able to work, rent, access your studies, and so on. However, many Europeans do choose to apply for citizenship for many different reasons. And that is a personal choice, and always in our campaigning at the Young Europeans Network, we always stress that this is a personal choice. Some people will choose not to apply, and that's fine, but for those who want to apply and want to become British, it's really, really important people make an informed decision, because as Lara said, it's a very costly application. It can be quite a long process for people, and in terms of collecting all the evidence and going through the process. So that is very important to actually have an informed decision on this. So what to do at the Young Europeans? Of course, we do informative session in collaboration with advisors like Agnete. We do a lot of Q&A, different documents, different videos. We have every Thursday some citizenship content just to inform people who may want to consider this path to be adequately informed about the options that are there for them. And also one of the important areas that we are working on at the moment is actually on younger people and children. There are around about 1 million EU children in the UK, and many of those children could possibly be able to register as British citizens. Many of them could even be born British, but because the citizenship laws are so complex, as seen by the many questions that we had today, it's often difficult for parents as well, especially for smaller children, to actually know what status the children have. So in the document that I will send to everyone after this webinar as well, there'll be some information about child applications. And on this front, we're working with an organization called We Belong, who work on different citizenship campaigns as well in terms of registration and citizenship by discretion to make this more accessible for people. So finally, before I will get some more questions for Agnete from the questions that she is considering now from the live chat on Zoom and on Facebook, just to say what are our priorities. Maybe people are asking what are we campaigning on. Currently, we're campaigning overall for the citizenship process to be more accessible for everyone, because at the moment it's not accessible from like three main points of view for European citizens. One, the cost. The cost is one of the main barriers of citizenship. The application fee itself is £1,330 for naturalization, which is the path that a lot of EU citizens will take, plus additional costs such as £50 for life in the UK, the English test if you need to do it. So overall, we're speaking about £1,500 or more on average, especially if you need legal advice, translations, and other things for one application, which can be quite a significant amount for many people. And especially if we think about families, think about if you have two parents from an EU country with maybe 3 children and they all want to apply for citizenship, this can be like quite a very, very significant amount. So we're campaigning for it to be more accessible from a cost perspective. It only costs the Home Office about 1/3 of this fee to actually process the application, for to pay for the staff and the processes that need to deal with this application. So we're arguing that the citizenship cost should be closer to what it costs to process rather than the fee that's currently. And also campaigning for more accessible information on citizenship, because of course there are government web pages and there's guidance, but as you have seen, often when you go on the government pages on the guidance, it can be quite confusing. It can be quite inaccessible for people who don't have a legal background to navigate, and often it's very confusing for those of us who are in the migration sector and campaigning on this as well. So more accessible information on citizenship. And also we're campaigning on the CSI issue as well, and who have been campaigning as a 3 million for a long time on the CSI issue that often presents as a barrier. But saying that although the CSI can be a barrier for some people, also some people think it's a barrier when it's not necessarily the case, as the example showed of students who had consistent part-time work that is considered genuine and effective, like Agnete explained. Again, if you can qualify as a worker, then there are some options for people who may have thought they can't apply due to that reason. So it's important to get the information out there. Some of our volunteers will put in the chat some links to some of our resources and campaign. So if you're more interested in the campaigning side, to join our campaign, the Young Europeans campaign, to make citizenship hopefully more accessible and a more positive experience for people, then please do join us. But now, because we have about 20 minutes left or less, I will turn to Agnete again to ask some of the many questions. We won't have time for all of them. I think we had about over 50 pre-submitted questions. I think we had over 50 live questions now. So I'll just ask Agnete a very quick fire round of questions, from starting with absences and proof of residence, and there are many of those from Zoom. How do you prove non-absence is one of the questions, and I think here we'll send some guidance, right? We'll send some follow-up guidance.
Yeah, so basically what we've gone through earlier, the guidance document, which is posted about citizenship, has all the examples of all the kind of requests you can make if you don't have lots of utility bills or HMRC stuff lying around, and how to do that. So I've put some links in there. So please go to our guidance document, which answers that question.
I mean, it doesn't make sense for you to go through some of the questions that you think are relevant on absences and proof of residence, and then we can move to the next topic. Maybe it's quicker this way to try to cover more in the next 15 minutes.
Should I pick a few questions?
Yes, from the absence, and then we can move on to the next topic. I'll see as well what has been so far.
So again, so here there was a question about I had a 1 year period where I was absent. This is more than 1 year ago. Is this allowable? Yes. So I answered that earlier. That the total absences of 450 days over 5 years, for example, can be distributed in any way, as long as in the last year it isn't more than 90 days. So you can have quite a long absence. You can have a year's absence somewhere else. So that isn't a problem. Someone wanted to know whether master studies count as residence. So there's two ways of answering that. Either you mean in terms of continuity of residence or lawfulness of residence. So in terms of continuity, yes, but it wouldn't be enough to just show your master's certificate. You would also need to have some points of contact, sort of utility bill here and a bank statement there to prove your actual residence. So that of its own is not enough. And in terms of lawfulness of residence, we're looking again at being a student. So master's studies do qualify you as a student, exercising treaty rights as a student. And again, the CSI will be a requirement. Right, so this is someone who has pre-settled status, but has been out of the country for more than 90 days because of the pandemic. So again, the naturalization guidance is really helpful here. Page 16 to 17 deals with excess absences, and one of the exemptions is to have been unable to return to the UK because of the pandemic. We have another question here about proving the first 10 years of life. So like I said, Red Book, medical records, school records, that will often cover it, because during the first young years of someone's life, there's always a lot of contact with the authorities, with school, with the NHS and so on. Because it's a rule, you have to get your immunizations in and so on, and all of your checkups. Right, there was a really interesting question here. Does the proof of residence period for naturalization have to be the same period you used to obtain your settled status? So the answer there is no, because for settled status, you could use an earlier 5-year period for settled status. So you could have someone who was in the UK 2012 to 2017 continuously, but then they spent 7 months abroad every year since then. So they would have to choose that earlier 5-year period to get their settled status, because otherwise it wouldn't work, because you can't have more than 6 months abroad within the 5-year period. But for naturalization, it is always counting back 5 years from application date, or counting back 3 years if you're married or in a civil partnership with a British citizen. So there's no choice of sort of moving the 5-year period around. There's another interesting question here. Due to work, I needed to travel 2 or 3 times a week abroad. Are absences cumulative, or are 1 or 2 day trips not considered as absences? So they are cumulative, but travel dates don't count. So it's only full 24-hour periods from midnight to midnight that count as absences. Okay, I'm going to repeat this again. There's another question here, because it is so confusing with all of these time frames. Someone says, suppose someone has been in the UK for 6 years, they have settled status now and have had it for 1 year. Do they need to wait another 4 years to meet the 10-year requirement? So again, I'm really sorry that this hasn't been clear, but it is up to 10 years that will be looked at by the Home Office for lawfulness. If you haven't been in the UK for 10 years, then they will only look at the whole time period that you were here. But if you were here for 13 years, they will only look at the 10-year period. So no, you can apply now, provided that you were in the country 5 years before your application. Always bear that in mind. This is actually about settled status, so I'll leave that out. Well, no, actually, if someone has pre-settled status in September 2022, they will have been in the UK for 5 years. When shall I apply for settled status? The answer is September 2022. absences. I'll try and find one more for absences. Right, how to prove absences. I would say someone who travels a lot for business, just keep a wallet of all of your travel bookings. Emails can be an electronic wallet, obviously boarding passes and so on, and maybe honestly keep a list of your dates, because it will make things a lot easier. I think that's covered it. I've looked at the other questions and the answers have pretty much been covered.
Okay, I think yes, there's some more questions on the general application. So again, we'll send a follow-up to everyone who registered for the webinar with some detailed guidance. So I see a question on proving good character. There's an entire section in the document about that as well. Yeah, maybe this one, there's an interesting question about having indefinite leave to remain on an old passport, if this is still valid.
Yeah. So that is, I just have to point out that settled status is indefinite leave to remain, yes, but it's better than the old indefinite leave to remain because you only lose it after 5 years absence. If you have an old style indefinite leave to remain, any other type of indefinite leave to remain that isn't settled status, that is lost after 2 years absence. So to prove that you still have it, you have to prove that you weren't absent for one single chunk of 2 years. So you need to then prove that, provide proofs of residence for at least, one item per 2 years.
This is not a very short question. Do I need a sponsor for my application?
No, it used to be naturalization applications could be done on one form and family members were cheaper, but that hasn't been the case for years and years. So each person makes their own application.
And also an interesting question about the referees. Again, we'll have more guidance on this in the document. We'll send as a follow-up. So it's about how to present this referees documents, how does it actually work in practice, and whether only one of the referees needs to be a British citizen.
So the guidance conflicts at the moment. There are places in the guidance that require both to be British, and there are other places in the guidance that require one person to be British and the other person to be of any nationality and over 25. So to be sure, it would be probably best if you do have the option to go for the both British citizens. But I'm going to, because I looked at it and I thought this doesn't actually, the guidance doesn't agree with itself. So I'm going to add this and some recommendation into our guidance document, because obviously it's not very helpful. But one person definitely has to be a professional and the other person has to be over 25.
There's a question on the chat. Isn't it better not to prove absences? I would say no.
I mean, you have to be truthful with your naturalization application can be refused if the UKVI find out that you haven't told the truth. So it's definitely not worth doing because you won't get your application feedback. And it always tell the truth to UKVI, but present it in the best light. You should always provide context. You should always have a covering letter. Anything that's ever so slightly problematic, just explain it and provide context.
Yeah, so that's definitely not a good idea not to disclose the absences. There are a couple of questions. So I'm not sure if you want to comment on that, but I think some people were confused about this. Well, the old permanent residency document that was under EU law and the settled status, and some people still have both and still have this permanent residency blue card. So what's the situation now? Can people still apply with this permanent residency card or not, because it's not valid anymore?
It won't be valid anymore after the 30th of June, but the naturalization guidance has been updated to say that someone who doesn't yet have settled status, but they do have a permanent residence document, that they can use this to prove that they are free of immigration time restrictions, but they need to get a move on. They need to apply before the 30th of June. Someone who has both permanent residence, a permanent resident document, not the automatic one I spoke about earlier. They need to have a document. So someone has a permanent residence document as well as settled status, they must use their settled status to prove their freedom from immigration time restrictions. But it is very useful to also use the permanent residence document, because that, the naturalization guidance says to the Home Office, you must accept this as proof that the person the person's residence was lawful for the 5 years before that, because that's what the requirement is for permanent residence. So then you don't need to go overboard with the lawfulness evidence.
And I think another very well easy and quick one is about what do you mean by proof of settled status? I think we said that obviously for citizenship, if you apply based on settled status, how will people be asked for proof of settled status in their naturalization application? What do they need to provide as evidence?
Yes, well, because it's in most people's cases, it's online status. So all that you need is just enter your 16-digit reference number. You don't really need to provide anything else. You can still, you know, if you want to, you can do a screenshot of your status, but it's not necessary because it's the Home Office's own system that recognizes the number.
Yeah, I mean, I still see some questions. Maybe we should take like one more. Do you want to choose any question from the open Q&A? There are like two very new ones if you want to choose any of those. And then we can speak just in the last 3 minutes about, you know, next steps and legal advice. I think there are two, one anonymous and one from, yeah. Can you see them, Agnete? Or?
I'm not sure if I'm getting the added questions. So I've got the Zoom questions, which we've gone through.
Yeah.
The CSI questions, I think we've gone through them.
Yeah, I think we've gone through most of them. I mean, there's only one, you know, one new one here about, well, it's a more broader question about how do I look for a referee? Can I use someone who is unemployed?
Okay.
As a referee?
Yes, if they don't need to be working as a professional, they can be retired. You know, for example, engineer, again, if they have the professional qualifications, and the list is in the general nationality guidance, which is linked in our guidance document. On page 25 is the full list of professionals. It's quite long. And yes, there's no requirement to currently be working in that profession.
Yeah, again, we have this, yeah, more detail on this in the document that was sent, that Agnete prepared, that was sent after the webinar. I mean, I'm not sure how, yeah, that's a very interesting question. I think it's more the discussion question, but there's about, does the Home Office have any special category for people who won national awards in the UK, significant achievements? I think some countries have this, you know, those categories of citizenship for like honorary citizenship. I'm not sure if the UK actually has this. I've never heard of it.
No, but if there's any issue under the good character guidance, such as CSI or even some minor things like a traffic fine or something, because the good character guidance is really worth reading. It includes so many minor things that weigh against you. So the good character requirement will be a balancing exercise. If the Home Office does their job, they will look at negative factors as well as positive factors and definitely mention your awards. Because they're a sign that, you know, you're making contribution in some way, that you've been recognized for, you know, being of value to the country. So definitely mention it.
Okay, so I think like we went through all the questions. Like in the last 2 minutes, we'll just go through like some questions about like, you know, what next. So someone asking, do I need to seek legal advice before making the actual application? Do I have to use a lawyer? What would you say to that?
I would say if you meet all the requirements, including the good character requirements, if you have read the good character guidance and there's absolutely nothing in there that causes you to think, maybe look again, then you're fine to apply on your own. But if you have any doubts about anything, then I would recommend at least getting some one-off advice from a lawyer. The consultation will not be that expensive, but will be, you know, save you peace of mind. Or even if you think you meet all the requirements, but then you've prepared your application, you're not quite sure. A lot of firms now offer an application checking service, which again isn't as expensive as instructing a lawyer to do everything for you. So I recommend you to get that input if you're not sure about something.
Yes, because someone also asked, can I send my papers to be checked? Is there an option where I can pay someone to check my papers? So I know there's this document scanning service. So when I did my citizenship application, I went to, but they only scan for you. They don't actually check it if they're correct. So there are two different things there that could be done.
No, a few years ago, I think it closed down in late 2018. There used to be a town hall checking service for nationality, but I think they've run into problems because all of us, I think it's because of us, because our naturalizations are so much more complicated and they would have just capitulated, just, you know, no idea. But so they've closed that down, and it's kind of a good thing because I don't think they were necessarily staffed by trained immigration lawyers. So no, unfortunately not. And also there was a question about, can I choose an option to have my application checked at the end of the form? So no, UKVI don't provide immigration legal advice, but you can find a lawyer on, for example, find a solicitor on the Law Society website or Advisor Finder on the OISC website.
Mm. And finally, I mean, I hope everyone's application, if you're thinking about doing it, will go well, especially after, you know, the information today. And yes, if you want to check further, there will be some recommendations of different organizations you could go to, and different links on the document we'll send after this webinar as well. But finally, if things go wrong and the application is rejected, can people appeal, and what's the process for that? What are the next steps if someone gets rejected?
Yeah, so I've added some information on the nationality review. Unfortunately, there is no right of appeal to the Immigration Tribunal on refusals of naturalization applications or any citizenship applications, but there's a nationality review which costs £372 and fees, and it will be reviewed by another Home Office caseworker. Essentially, what they will look at is whether they have considered things correctly. So they should really, the Home Office should give you a chance. If they think you haven't evidenced something enough, they should give you a chance to send in more evidence. So it's a sort of a fairness process, you know. So if you've been refused something on the basis that you haven't evidenced something enough, and there's just sort of one document missing, then you could ask for a review saying that this wasn't really procedurally fair. Or where we're talking about the discretion under the good character guidance, if you think that they haven't considered, for example, the positive factors in your case, your awards and your volunteering and all of that, they completely haven't considered that, and all you've done in the past was spend 3 years here as a student without CSI because you didn't know, then that might indicate that they haven't done things properly, that they haven't considered your case properly. So you can then put in that request for a review, and it might be helpful to really get a lawyer to maybe write a covering letter for you. Because this gets into quite legal territory.
Thank you very much. I think we're 1 minute over time. I'm aware there's still some questions on Facebook around. There are other things around dual citizenship. We actually have a few documents prepared in the 3 million about which countries allow dual citizenship and which don't. So I'll link to that so you can check whether your country allows it. So there are some differences across different EU countries depending on which country your citizenship is from. So I would say, well, thank you very much to Agnete for staying for 1 hour and a half with us and answering. Probably we covered about probably 100 different questions or variations of questions, so a lot in an hour. We'll have a follow-up email. This session was recorded, of course, was on Facebook Live and will be also on our YouTube channel. So we'll send an email from the Young Europeans with the document that Agnete referred to, and with some of the answers to the questions, the more general questions, the guidance, and the link to the recording as well, so you can rewatch, because we realize it's quite a lot of information, so it's maybe worth rewatching this section that was relevant for you. So yes, and if you want to be involved in making citizenship more accessible, including supporting some more, outreach and informative sessions, you have the links to different organizations there, including the Young Europeans Network in the chat. So thank you so much, Agnete, and thank you very much, everyone, for your questions and your participation this evening. Have a very good evening, and good luck with your applications if you're doing a citizenship application.